card. And today's topic is, of course, like we said earlier, the PWD. So, what is it? What is PWD? What is prevailing wage determination? And maybe you could also catch up on the essential. Why is it so essential? For the employment-based green card applications and even the regulations for it. So,
Yeah, absolutely. So prevailing wage determination, or as we say, the PWD, so that we don't have to keep saying prevailing wage determination here today.
yes.
It's also known as the ETA 9141. And the ETA 9141 is the form that is used to actually file the PWD with the Department of Labor, right? And it's important for a few different reasons. One being that it is the very first initial step of the PERM labor certification process, right? So when we submit the ETA 9141 or the PWD, as it's better known, what we're telling Department of Labor is that an employer is willing to hire and sponsor someone after they've got a green card in various employment based categories. And in the 9141, what we list out are various job responsibilities, any specific skills that are associated with the job, any specific education requirements that are necessary in order to do this job. And we submit all of those details to the Department of Labor. And what they do is they issue a prevailing wage. And what that prevailing wage is meant to do is essentially say, hey, this is the appropriate wage level for this particular job based on all of the job requirements, all of the skills, all of the education, all of the work experience that you have listed out in this form. And really, it's meant to protect foreign workers, right? Because it makes sure that you're not being paid below a certain wage level based on those requirements. And it's also meant to protect domestic workers to make sure that there aren't any workers within the United States who are capable of doing that job who would be displaced, by this type of sponsorship. So, in a nutshell, to summarize, the ETA 9141 is meant to obtain a prevailing wage for a specific job, for a specific individual at a very specific location based on job requirements, job skills, education requirements, and work experience.
All right. And since we're talking about it, maybe you could tell us about the ways to file it. Online, paper, how do people go about the whole process of applying for it?
Yeah, it's very straightforward in the sense that the Department of Labor has created this flag system online, right? So you can submit a case or an application for the 9141 online. I don't know why anyone would want to do this by paper when, the online capabilities exist where, an employer or maybe the employer's attorney already has an account on the Department of Labor flag website. All they need to do is just go to cases, open up a specific application for the ETA 9141, and then they simply submit it, right? It's a very straightforward process once it's done online.
Awesome. That's true, actually. And maybe you could also tell us about the timelines, the current timelines for PWD determination. Well, of course, I think we'll catch on it earlier, a little later, but we have something on the screen which is about USDOL. So let's talk about it and also the NPWHC fee for PWD.
Yeah, yeah. So all these acronyms, right? The USDOL is the Department of Labor, right? The United States Department of Labor. Within the Department of Labor, there's an organization called the National Prevailing Wage Help Desk Center. And basically, what the NPWHC does is they are the ones that actually issue a determination or a prevailing wage on the ETA 914.
Okay. All right. So let's hit on to what PWD determination, the current timelines, for the determination of PWD. It used to be about 45 days. And what about nowadays?
Yeah, excuse me. It's definitely not 45 days anymore, right? So it, typically it should only take about 3 to 6 months to get a PWD back, right? I have seen instances, I think there's a case that I did myself where it took about 13 months to issue the PWD from the Department of Labor, right? At about month 11, we got a request for information or an RFI from the Department of Labor, where they basically said, hey, look, we see that you're sponsoring this individual for a business analyst role, but we feel like we don't have enough details about the job, right? And so they issued an RFI where they asked for more information. They wanted us to get a little bit more granular in terms of the job responsibilities. And then it came back, approved, or the PWD was issued about a couple of months later. But typically, it should only take about 3 to 6 months. There have been longer and longer processing times, I would say, over the last couple of years. So don't be completely shocked if, a PWD maybe takes 8 months or 9 months or even pushes close to a year in some instances.
So it really delays. I mean, I was thinking 45 days is long, but then you're talking about 13 months and 6 months, and it's really long. Why these delays, though? Is it the same for everyone? The reason?
Yes, right. So at least for the PERM's labor certification process, right? Where you fall on that timeline of whether you're 3 months, 6 months, 9 months, or 12 months, you're never really going to know. It's a matter of when the officer at the Department of Labor, picks up your file, takes a look at it, right? And again, some individuals get it very quickly in that 3 to 6 month time frame, and there's some individuals
Mhm.
that do end up waiting 8 to 9 months just to get a PWD, right? So if you think about the length of the firm labor certification process, in and of itself, it can take about 12 to 18 months end to end from PWD to PERM to I-140 filing, right? And getting an approval back on that. And that's if you're staying within the average timelines. If your PWD itself takes about a year, you might be looking at a perm labor certification process that's going to take 2 years, right? Because the perm process itself can take about 6 to 8 months, and that's pretty common, right? And that's
Mhm.
if you don't get audited at the perm stage. So, there's no consistency, unfortunately, and I wish I had a better response to that or a better answer to that, but that's kind of the ambiguity that immigration attorneys live in, and so do employers, when they're going through this perm labor certification.
Mhm. Hopefully, though, these delays will shorten up and maybe it won't take that much long anymore.
Yeah.
Anyway, so do you think the PWD indicates the green card?
It does not, right? So, and I want to back up a little bit, right? Because like the very initial step, almost at like a consultation phase or consultation stage, when I'm meeting with a client or an employer, one of the first things we talk about is, what is the beneficiary, right? What is the employee's qualifications? Really, the determination of an EB2 versus an EB3 is going to happen, at least for me, and probably most immigration attorneys, in that initial consultation, right? Where we decide, hey, based on the job profile, based on the job responsibilities, based on the individual skills, based on their experience, based on their education qualifications, where do they fall, right? EB2 versus EB3. From there, right, we take all of that information and we put it into the ETA 9141 or the PWD, and get a prevailing wage. So at the filing of the PWD, we're not deciding at that point, or at least indicating to the Department of Labor at that point that this is an EB2 versus an EB3 application, right? Um, Even at the perm labor certification stage, we are not indicating to the Department of Labor of whether it's an EB2 or an EB3. It's only at the I-140 stage, right? The petition for alien worker, where we're actually telling USCIS that, we filed these applications, we've done the requisite recruitment, and now we're informing you that, hey, look, this is going to be an EB2 professional or an EB3 skilled worker, right? So again, at the very initial consultation, we are making a determination internally. But when it comes to the Department of Labor process, There's nothing that we're informing them about in terms of EB2 or EB3. That only really comes when USCIS, United States Citizenship and Immigration Services, when they come into play and the I-140 application is in play, that is when we indicate whether it's an EB2 or an EB3 application.
Okay. Wow. It's very deep, and everything is so detailed, and it's lovely to get to know. I mean, it's definitely eye-opening so far. We've got a lot to talk about, Attorney Prashant, today, and thank you so much for answering our questions.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.